The following is a legal advertisement. This does not constitute individual legal advice and should not be construed as such. This podcast is for informational and educational purposes only. My name is Michelle Gamino, and I am the Client Resource and Business Development Coordinator for Gwendolyn J. Stirk and the Family Law Group. Our speakers today are family law attorneys Gwendolyn Stirk and Jennifer Nolan. Today's topic is enforcing a court order.
Hi, everybody. My name is Gwendolyn Stirk. I am an attorney here at Stirk Family Law, and I'm here with attorney Jennifer Nolan. And today we're going to talk about enforcing court orders.
Right. So I think the issue that has arisen has been what to do if my significant other or ex-spouse is not obeying the court order.
Well, yeah, after all, it's just an order. It's just
Right.
a piece of paper unless it's enforced, right?
Right, and I think that's what some people think, that it's just a court order, that we can make up our rules as we go, as long as, it doesn't hurt anyone.
Well, that's really a bad attitude, because the bottom line is that the orders do have teeth if you get back before a court and they're willing to enforce it.
Right. So I think what we should talk about possibly is how we go about enforcing the court order and what happens if you don't abide by the court order.
Okay, well, let's start with a hypothetical question then. So I have a support order, and I'm supposed to be receiving $2,000 a month in child support and $3,000 a month in maintenance, and my ex is self-employed and I haven't received a darn cent. What do I do?
First, you need to come to Gwendolyn J. Stirk and the Family Law Group, get advice, and what we will advise you is you need to start the procedures of filing a petition for rule to show cause to find the other person in indirect civil contempt of the court order.
And that rule word sounds like, when you're reading a pleading, they're always praying for contempt or praying for relief. What's a rule? What's that mean?
Well, what you're doing essentially, in layman's terms, you're telling the court that the other party has not complied with the court order, and you're asking the court to find them in contempt, in which the other party, the burden shifts once the rule issues.
What burden?
The burden to prove that there was a contempt or violation of the court order.
Okay, but what if I didn't have the money to pay? So I walk into court and you go and I file this motion and I'm supposed to get this $5,000 a month, and my spouse walks in the door and says, I don't have it, can't pay it. What happens next?
Right. So that's the kind of the burden shifting. You make the allegation, I haven't received this $5,000 a month, and it's up to the other party to say, look, I had the inability to pay. I could not pay, or to give the reasons as to why they did not comply with the court order.
Well, I needed to pay for my own housing, I needed to pay for my dog, I needed to pay for my business operation. Is that enough of an excuse to avoid following the order?
No, I do understand. We have bills, we have other things to pay, but you're also under an obligation in a court order. So you have to make arrangements once this court order is entered, to be able to provide the support as well as to provide for your household expenses.
Okay, but say I come in there and I say, okay, my spouse owes me $5,000 a month and they're not paying. Are you trying to tell me that I have to put up attorney's fees in order to file a motion?
Yes, you have to. This is what you'll have to do when you're filing a petition for rule. You have to work out your retainer agreement with your attorney, and if indeed, in fact, the court finds that the other party is in contempt or his actions were willful, then you could ask the court for the reimbursement of your attorney's fees.
So they would not only then have to pay what they originally owed, but then possibly additional attorney's fees?
Correct.
Okay. Well, that might be a reason to go in, but what if the court doesn't give me my attorney's fees? Aren't I just chasing good for bad, or do you think I should still try?
And that's one of the things I think you need to come in and talk to an attorney about, to see what is out there owed, what you can do to collect on that, and whether it's the right time to file the petition.
Okay, so I have another question. So let's say that I file my motion, the burden shift, as you say, for burden of proof to say, okay, I violated the order willfully and I'm found in contempt, but I still don't pay. What happens then? Does anything happen, or are we just end of story?
No, it's not the end of the story. And unfortunately, some people think, as long as I explain I can't pay, but they show no proof, what they could possibly face is, again, the attorney's fees. They could face possible to be remanded into custody and face jail time. There are other...
How long? That sounds like a good idea. Put my ex in jail for not paying me, right?
Right, and I think it depends on the judge and the facts of the case. case and how much you're owed and whether your actions were really willful.
Is there a
To the
maximum
point-
amount of time that I could be in jail if I violated a court order? Isn't it
I think it's-
180 days?
Yes.
So 180 days I could end up in jail. So, okay, so maybe I don't want to pay you. I'm really ticked off. I owe you $5,000 a month, so I risk it. Somebody else can run my business while I'm in, and I sit in jail for 180 days.
Okay.
I get out, nothing can happen, right?
No.
What else
The
can
order
happen?
still exists. You would still have to pay. It'd still be enforceable order. Just because you serve jail time, you're serving because you're violating a court order, not because you're trying to trade jail time for paying your court-ordered responsibility.
Yeah, and my experience over the years as an attorney, as a side note, is sometimes people aren't afraid or they think the judge won't do it. And then one night in jail, and all of a sudden they didn't have a penny. They couldn't borrow it from, Timbuktu, but now they can come up with the money that they need to get out of jail. Now, I have another question. Is the judge going to require that I pay everything back at a lump sum payment, or is the judge going to give me time?
No, I think most judges, what they'll do is based on your financial circumstances, they might order you to pay like $1,000 up front and then thereafter set a monthly amount to pay each month. But if you have the ability to pay all in one, then the courts might order you to pay all in one.
Well, then the other issue is that, so you didn't pay me for a year. You owe me $5,000 a month between maintenance and child support. That's $60,000 in a year. I didn't want to spend money for attorney's fees to go back after it, so you really got to use my money. Do I get any other benefit, like interest or anything else accruing on
yes.
these unpaid amounts?
Absolutely.
And what kind of interest?
Annual interest, 9%.
Boy, I should do that instead of going to a local bank. That sounds like a good deal. Maybe I should get a judgment.
Yeah.
So 9% interest. So that's interesting. So you have the liability then for the 9%, the potential for attorney's fees, and the potential for jail time. Is that
Yeah.
my understanding?
Yes.
Okay. And what if the other spouse then says, I'm not making the money I was at the time of the entry of the order? Aren't I at risk that they could try to modify the underlying order and reduce the maintenance and child support that gets paid?
They could, but it doesn't excuse the fact that before they never had a motion on file to reduce, so they're still obligated to pay that amount that was entered before. But you are absolutely correct. If there's a change in circumstance to where you're not earning as much as you were at the time the order was entered, you could absolutely file a motion to modify with the court.
Well, I think that this also relates, though, just so I'm clear, on other things just other than money. So if
Yes.
you don't deliver the deed to the house or the personal property, whatever it is it true that you can ask for a petition for rule to show cause to hold somebody in contempt for any type of violation?
Absolutely. If it's in the court order and you do not abide, if you were supposed to deliver documents, if you were supposed to sign a document and you do not do it, you are violating a court order.
And what we're talking about here today is civil contempt, is that correct?
Correct.
Now, if I pay it, let's just go one step further. So I got $60,000 behind, but I decide that I'm going to borrow money from my great Uncle John, and he's going to give me money to pay it off in a lump sum. Have I now completed? What happens with the contempt at that point?
I would arguably say that you can still be on the hook for attorney's fees for me or for the party having to file a petition for rule to show cause for you failing to do what you're supposed to do. I think you could still seek attorney's fees because it wasn't until after the fact that you complied with the court-ordered action. Now, whether you can be found in contempt, the question is whether or not you have a purge, if you've already done the action that was required to you in the order.
Okay, but let's just say that you get a purge. So I was found in contempt, a purge was entered, and I paid it off. Am I still in trouble with the court, or is it then over and done?
Well, you have satisfied your contempt, but you'll still be on the hook for attorney's fees, and you still have to abide by the court order going forward.
Very good. Well, I think the lesson in all of this is watch out. If you get a court order, make sure you're following it. And if you don't have the ability to follow it, you should talk to somebody about trying to modify it. And if you're the person who has the court order and somebody else isn't following it, then you should contact our office and talk about what your remedies might be.
Correct.
We offer free consultations, and there are other matters. There's new child support laws in 2017 and things to be addressed, but we look forward to hearing from you, and we give free consultations here at Stirk Family Law.
The proceeding was a legal advertisement from Gwendolyn J. Stirk and the Family Law Group.